Thank you very much, and good afternoon, everyone. It is a great pleasure being here today in this amazing venue, surrounded by renowned professionals who I have always admired, and now I have the pleasure to call colleagues. It is a huge honor and responsibility to be here representing the Brazilian Arbitration Committee as its former chair. And for that, I need to thank very much the organizers of this symposium, André, Felipe, and João, who have not given up on me, as I was invited to participate in this event since the first edition, but only now I have managed to come. Thank you very much, guys. Okay. Having said that, I would like to start by clarifying how I have prepared my presentation. The organizers challenged us with the mission to respond to the question as to whether or not institutions should help regulate arbitrators. To answer such question, I believe it is essential to explore the different angles of the arbitral organization's role. And to that, we need to differentiate academic and non-profit organizations, such as CBAR, IBA, CR, from the institutions in charge of the administrations of arbitral proceedings, such as CAMP-CCBC, the main sponsor of this conference, and the most prestigious arbitration center in Brazil, represented here by its president, my dear friend, Carlos Forbes, who I would like to congratulate for the outstanding work done ahead of the institutions in the last years, which makes the Brazilian community so proud as all of us collect the benefits of the success and acknowledgement of this organization throughout the arbitration world. I apologize for using some of my time with this brief greeting, but I think that CCBC is a true example of what an institution can do to help the development and the strengthening of the arbitration practice in a given country, as we have experienced in Brazil. But the focus of my presentation will be the importance of CBAR, an academic non-profit organization to enhance consolidation of arbitration in Brazil and to help guaranteeing the use of best practices of arbitration and ethical behavior by arbitrators. In order to assess the role of arbitration organizations, such as CBAR, it is important to understand where we are in terms of the evolution of the arbitration and its impact on the market we work in, to see how and where these organizations can exercise their mission. It is common sense, or at least it should be, that arbitration is constantly evolving. This is a natural consequence of the increasing use and sophistication of arbitration to meet the user's needs. And this evolution, as everything in life, brings with it pros and cons. And I will give you only a couple of examples of these two sides of the coin. On the pro side, we have the increase of the number of cases, which provides better work opportunities for lawyers and arbitrators, and increases the income of the arbitration centers. And the the enrichment of experience of the arbitration players who have the opportunity to learn new things with each different case they work in. On the other hand, there is a greater chance for the advance of difficulties and problems with the expansion of the arbitration cases. And of course, inevitable occurrence of complex procedural challenges that requires strong and efficient conduction of the case managed by the arbitrators to find creative solutions within the boundaries of the applicable laws and regulations. I believe that we all agree that the notion that arbitration was almost perfect to resolve conflicts, especially time and cost-wise, no longer exists. When I started studying arbitration 20 years ago, I used to have this romantic view of arbitration, having eyes only for its amazing advantages. My more experienced and skeptical eyes now see it quite differently nowadays. In 2012, 6 years ago, Professor Ian Paulson affirmed in its keynote speech of ICA 2012 conference in Singapore that by then, we were living a new age of arbitration, which would be, in fact, its golden age. He said, "Never before have so many controversies been left to the disposal of arbitrators, and never before has so much autonomy been afforded to them." Nowadays, some people say that winter is coming. It is true that today we have been seeing quite a few challenges that require stronger attitude from the arbitrators to avoid that emerging problems end up jeopardizing arbitration as the preferred method of resolving complex disputes. Unfortunately, more and more, the parties are using the so-called guerrilla tactics and adopting a harmful behavior during the arbitral proceedings that Professor Bernardo Cremades named as due process paranoia, with frequent occurrence of judicialization of arbitration. In 2016, on the occasion of the Chartered Institute of Arbitrators Alexander Lecture, Professor Cremades highlighted the abuse of due process in international arbitration, saying that it has become a real threat to tribunals. In his wordings, and I quote, "In this day and age, we are living in times of significant conflict. Arbitration has ceased to be a method for resolving disputes between gentlemen, to become a vast industry where it would seem that aggressiveness is a virtue for the lawyer defending the party's interests. The truth is that the arbitrator's life is not an easy one. We are challenged in every case with new different kinds of issues raised by more and more creative parties that sometimes we have never thought about it or had never faced it in the real life. And we need to find a way out of this situation so that arbitration does not lose its appeal for the final users. How can we find solutions for these problems? Who can help us out? It is important that the arbitral community, including practitioners, arbitrators, and institutions, join efforts to think about it, offering opportunities for reflection of academic and practical matters that impact on the accomplishment of the arbitrator's mission by promoting discussion forums considered as neutral territory that gathers professionals coming from different cultures so that we can learn from each other's best practice. We need to reflect on what we as a community have done right, but more importantly, on what we could do better. I truly believe that the evolution of arbitration is, or at least it should be, associated with the integration of cultures for the implementation and consolidation of best practices. This is where I see that academic nonprofit organizations such as CBAR have a very important role. The arbitration community must be constantly and efficiently updated on how arbitration is working worldwide to identify strength and weakness, and from there, encourage improvement and find solutions for emerging problems. Therefore, I see that organizations should offer tools to promote opportunities to exchange of information and experiences among academic and practitioners, so that we may achieve a common place for best practices that meets the needs of the arbitration community, providing an efficient resolution of controversies. Moving to the second part of my presentations, let us briefly see what CBAR have been doing as a vehicle towards implementation of best arbitration practice in Brazil. Well, CBAR is an academic nonprofit organization whose main purpose is to disseminate arbitration and other ADRs in Brazil. It was founded in 2001 by a group of young and visionary practitioners. By then, arbitration merely existed in Brazil. And it gathers nowadays approximately 108 scholars, associates between scholars, practitioners, law firms, arbitral institutions, students, companies, and other professionals. CBAR offers a great contribution for the consolidation of arbitration practice in Brazil. It's moved by a constant effort to ensure the highest quality of arbitration held in Brazil or by Brazilians, lawyers and arbitrators. It invests on empirical market and academic researches, engages in international projects to promote integrations of cultures. It provides continuing professional development for experienced arbitrators and lawyers, and also contributes for the formation of a young generation of professionals engaging in arbitration practice by a wide range of academic projects and network opportunities to help their inclusion in the arbitral community. Let's briefly pass on some of the main projects. In 2012, SIBAR promoted an extensive opinion survey with arbitrators, lawyers, in-house counsels, and arbitral institutions. There were 158 respondents, 23% female and 70% male, a range of 23 years of legal professional experience, and 67% over 10 years of arbitration experience. The main goal of this survey was to put arbitration and its agents or actors in the mirror. It gathered a lot of important information and perspectives on the functioning of arbitration in Brazil, including lawyers and arbitrators' skill and ethical behavior and quality of the services rendered by arbitral institutions. The results of this research provided important elements to enable reflection and discussion aiming to enhance arbitration practice in Brazil. SIBAR also promoted two case law researches to map and comprehend how Brazilian judges apply the Brazilian Arbitration Act based on empirical research. It covered decisions by the state courts of appeal and by the Supreme and Superior Courts of Justice. The first one was held in 2007, conducted together with Fundação Getúlio Vargas Law School, and the second one was concluded in 2016 with the cooperation of the Brazilian Arbitration Students Association, the ABARB. It covered 100,000 decisions, and the focus was on the decisions rendered by the Supreme Courts. And we have put together analytical reports on some of the important issues discussed within the state courts, such as existence, validity, and efficacy of the arbitral convention, validity of the arbitral awards, enforcement, recognition and enforcement of foreign arbitral awards, and other issues. And it provided very useful information to the arbitration community related to legal certainty. SIBAR also promotes an annual conference, which convenes a productive and enjoyable academic debate on relevant issues related to international arbitration. These are very rich opportunities for us in Brazil to hear from the international community, to learn best practices from our colleagues worldwide. We've also been made in some international projects, joint events with prestigious international institutions. In 2014, an event with the Comité Français de l'Arbitrage, in 2016 and 2017 with the Queen Mary University, and also in 2016 with the New York University. It promotes Brazilian arbitration internationally and provides unique opportunity to exchange experiences with international arbitration community to enhance arbitration practice in Brazil. We also have a commission that monitors the legislative treatment of arbitration. And it tracks all bills of law and legislative proposals aimed to rule on arbitration and other ADR issues. Nowadays, we have about 70 bills to be voted within the Congress in Brazil. And we are always trying to find a way to avoid that those bills go through and jeopardize all the good work we have been doing in Brazil. And we have some other projects that I'm not gonna waste your time with those, and I'm sure that if you want, the organizers can circulate the presentation because I am running out of time. So in conclusion, we finish where we have started, answering the questions proposed by the organizers. Do arbitral institutions should regulate arbitrators? From the point of view of an academic nonprofit organization, I don't think so. I believe their role is to provide arbitrators with the necessary tools to enable constant education in order to improve their skills and keep them open-minded to face the challenges that inevitably come together with the evolution of the arbitration practice and help them to find solutions. This way, they might regulate themselves and act according to what is expected from them by the final users of arbitration, being efficient when deciding the case, especially as regards time, cost, and observance of due process, and with the higher standard of ethics as per the best practice adopted or worldwide. Thank you very much.